And we are live.
All right, thank you. It is April 27th. This is Senate Health and Welfare, and we are looking at our amendment on H-171 and trying to get to closure on the work with that bill. And then a bit later, we'll be looking at H-414, but H-171 is the Adult Protective Services bill, and Katie is here.
I'm here, but I'm not ready. I'm sorry.
Not quite well, just take a second to get ready. So, and we've been looking at a number of issues in the bill. And there is a proposal of amendment that gives on those, actually 3 issues on the bill. So Katie's gonna bring it to us. And I thought what we will do is we'll look at the proposal of amendment and the bill, trying to have a context of what the amendment does.
Can we,
Understand.
just was told that there was a memo that was sent to us on Monday. I'm just looking at it now. I don't think it was actually sent to the committee,
I had it posted for us.
but I didn't know it was there. So I'm wondering if they could come up and explain the memo, their options.
Oh, on the, we can do that. Stuart, you are here. We had a memo. Would you like to come up and explain it? We have heard the concerns. I would like to restate what it is. We have heard the concerns from Dale, and we've heard them, and this is another iteration of the same concern that we've heard previously. It is stated slightly differently. So if you wouldn't mind coming up, and you can state the concern that you have, that we have heard. I don't think we have enough.
It's on our website.
Well, I couldn't find it there.
Yes. That's right.
Yeah, we received it from the legal counsel.
I just want to understand this issue better, and
It's under Rebecca's name.
yeah.
Did you want to talk about it?
I'm not gonna talk about it. I just
Okay, why
couldn't
don't we
find
do
it.
that?
It's too sweet.
Yeah.
It's rather lengthy. I will try to, in the interest of time.
I think summarizing it would be helpful,
Sure.
because it does, I think essentially it agrees with the position that you presented previously.
It does.
In a slightly
it
different
does.
way, right?
What
It's not a new position.
Okay.
It's the same thing.
it is,
Yeah.
it is what I stated when I was here last. It does offer some proposed options for the committee's consideration. I noted that they're not included in the draft proposal. However, the department does want to reiterate there are 2 issues. One has to do with the inclusion of the negligence mens rea in the definitions of abuse and neglect. And the memo specifically addresses the fact that the definitions of maltreatment are outdated to the extent that they don't necessarily comply with what the national standards are with respect to the inclusion of the negligence standard, which is the lowest burden for the department to demonstrate. And as I stated earlier, there are, under the current statute, the department, for both abuse and neglect of a vulnerable adult, the department must prove that the individual acted with reckless disregard or purposefully, but not that they engaged in some sort of a failure to follow a duty of care that they owe to the vulnerable adult. We would ask that the definition be expanded to include situations where a caregiver or any other individual engages in conduct that results in an outcome as a result of a failure to provide the duty of due care that individual owes, whether it be a professional duty of care or just a standard duty of care that an ordinary person would owe to a vulnerable adult. And so I know that since our last testimony, the committee received some written testimony from Vermont Legal Aid and from the Community of Vermont Elders and from Disability Rights Vermont.
Yes, but just speak to your
Oh,
memo
I'm
if you
sorry.
don't.
I'm sorry. So that would be the issue that the department wanted to reiterate, that there is a very low substantiation rate, that about 1% of the cases right now are substantiated for abuse and neglect. And that we believe is in large part due to the fact that there is at times a heightened burden on the department to prove that someone acted recklessly or purposefully before they can be placed on the registry. With respect to abuse, we understand to a degree why that's an issue, but to say that someone cannot act negligently when it comes to neglect doesn't seem to make much sense. It would leave the department with very few tools to demonstrate that somebody should be substantiated for neglect. If you couldn't show that their failure to follow a duty of care to that individual resulted in harm.
Mhm.
So that's why we'd ask, if for nothing else, that with respect to negligence, with respect to neglect, that the negligence standard be included, even if you choose not to include a negligence mens rea for abuse.
Okay,
And
so
that's-
I guess the question then it gets into the frequency with which errors are reported and the time frame during which there are inspections and reports that come to the department from various facilities, residential facilities, nursing homes and others. Can you talk to that a little bit?
Maybe I could ask John to speak to that. John Gordon is our director of APS.
Yeah, good.
John Gordon,
Sure.
Director of APS.
I have a question for Stuart too.
Okay.
But
Yeah,
if you
well,
want,
that's
yeah,
Stuart's
you
question.
can play musical chairs a little bit, but
Go ahead.
Could you rephrase the question so I understand it?
I'm just trying to understand the frequency with which our care facilities are inspected and then the number, how many times errors are reported, what's the reporting mechanism, what's going on? Because it sounds like there's a concern around at least.
So in terms of the inspection of care homes, that would be the province of survey and certification. In terms of investigations that are conducted within facilities, we do conduct maltreatment investigations within facilities. And the timeframes, the response time on the screening decision is up to 48 hours in this bill. And in terms of the types of things that are reported, majority of the reports that we receive have more to do with the failure to follow a plan of care than specifically failures of like errors of medical errors. Things that have been discussed as an example, leaving the sponge behind the. Go ahead.
So the plan of care, and it does get to what Stuart was talking about, that's why I asked it. So if there's a plan of care to how would that
So
deviation
example,
from the plan
Sure.
be? So if someone didn't come into my room within a half an hour,
Mhm.
then is that abuse and neglect? And I was there at 35 minutes later. How is that interpreted?
So there's multiple parts to the definition. The one part is the failure itself. The part of the question is the status of the person who failed. What were they thinking? Currently, it's reckless. We would like to see that as negligently. But there's also whether the person was a caregiver, whether they were specifically designated to provide the care. And then there's the severity of the care or severity of the implication of the care not being done. So that we have to also establish that there was harm or likely to be significant harm. So simply the failure is not.
So if someone were left on the bathroom floor after falling and were left there for 2 hours, that would constitute abuse.
That it could constitute neglect if we would establish that someone was supposed to check. We would have to establish.
If that were in the plan. But if someone had fallen and 3 minutes passed before they were helped, then, and that the plan said should be immediately checked, how would you deal with that? As I said, this is getting down to some
Yes.
things that I find really difficult to interpret.
Yes, so if someone fell and they were left for, say, 3 minutes, we would have to establish that an individual was, in that case, the requirement would probably be 24/7 eyes on. And then we'd have to establish that in the current law, we would have to establish that the reason that they didn't do it was because of some reckless failure. They knew of the risk and chose to turn away, so to speak, anyway. So we would have to establish both those things to substantiate.
Questions here, and then we'll get your questions for Stuart.
How do issues like insufficient staffing or things like that come into play? So if somebody in center lines, example of somebody's fallen and it takes a long time for somebody to come because they have too many patients to get to, how does that play into your considerations?
So we have had cases like that. And what we would look at there is the circumstance around, once again, the circumstance around why it was that the care wasn't conducted. If there was more care to do than there were people to do the care, and we could see, we couldn't show that the person was doing, they were doing their job, and there's just not enough of them to go around. Well, in that case, they weren't being negligent, they were being overwhelmed.
Yeah.
That's quite a bit different from a person, for example, taking a nap on the couch while there's care needing to be done.
Right,
for
right.
instance. So,
Or if there's an emergency in another room that they have to
Yes.
attend to, and
Yes.
something happens during that emergency.
yes, so that's one of the things that we have to establish, not only, like I said, was the care not done, but the circumstance around it. And for something to even be negligent, you would have to say, well, the reason why they weren't taking the care that they should have. Well, if they were taking care of 20 people when the time says you could have taken care of 10, then they were providing care and doing their job during that time. And they were put in a position where they could not know.
Okay.
Senator Lee.
Just curious in the question of insufficient staff, if your people, when they look at potential neglect or negligence, do they elevate it up a level to the management or to those that staff?
There have been, okay, so we often have tried to do that, but the difficulty with that is for there to be neglect, for instance, then the neglect can only be done by a caregiver. And if you look at the definition of caregiver as it's currently in law, the further you get up from direct care, the more abstract the idea of caregiver gets, and it becomes very difficult to tie like a supervisor who does not provide direct line care. It gets very difficult under our current definition to define them, to call them a caregiver. So it becomes very difficult to tie them and substantiate them. We have looked at those cases. We've attempted to substantiate those cases, but based upon the definition as it currently is, it's one of the things we're looking to change. It typically falls apart as things become more abstract.
Thank you.
So, but I mean, then we begin to get into the licensure issue and relicensure issue and suspension issue and so on. So it snowballs a little bit. And the rules that are in place now, the result of 171 will be a redrafting of rules. Is that going to happen or not?
Currently, we do not have rulemaking authority in our current law, so we do not have rules. And so there is rulemaking authority written into this bill, and so part of the process would be drafting of rules under this bill if it were enacted.
Okay, so some of the questions that we're asking and the concerns that are being expressed around neglect certainly can be addressed in rules at some point when I'm looking past you to Stuart. Stuart, maybe you could come up and ask, well, I have one more question and then we'll move on.
My question.
Yeah.
Okay. So I know you're a lawyer, so I'm going to ask you to not to be a lawyer for a second.
That's like asking a cat not to be a cat.
No, so could you explain in your memo, and you've used this a bunch of times in your testimony, can you put in plain language what mens rea means?
Sure, it's the mental state that's required of the actor. So every offense, every crime has, and I'm gonna try not to be a lawyer here. It has an act and it has a mental state requirement. The
Okay.
act is what the person does. The
Okay.
mental state, if there is one in a statute, is did the person act with negligence? Did they act knowingly? Did they act recklessly? Or did they act purposefully? And it's an ascending scale. So the lowest standard is, did someone act negligently? Meaning, did they act in violation of a duty of care?
Mhm,
And purposefully or intentionally is the highest.
mhm.
And that means that they did the act with intent or purpose.
Okay,
So there's everything in between.
okay. So in the example of somebody's fallen and the nurse doesn't get there to help them for an hour or whatever, and if the nurse doesn't get there because they're tied up in another room because there was an emergency, or if there's understaffing, then the mens rea is just they are overwhelmed. They are not negligent. They're not intentionally abusing somebody. They can't literally get there because of staffing issues or emergencies in other areas.
I would say that, as John just testified, that would be taken into account as to whether that was a breach of a duty of care, whether that was negligent conduct for them not to be there. And if in fact they were overwhelmed, there was a staffing requirement of having one nurse for every 10 residents, but there was only one nurse for every 20 residents.
Right.
Would that person really have been considered to have breached their duty of care because they were down the hall helping one of the other residents in
Right.
the facility? So I would not think that that would be negligence, but or neglect, but I would point out the definition of neglect requires that conduct has resulted in or could be expected to result in. So in physical or psychological harm. So if someone doesn't get to a resident in 3 minutes, even though the plan of care says that they have to be there
Mhm.
at all times, did that failure to get there in 3 minutes result in actual harm, or could it be expected to result? That's another consideration.
Mhm.
And I wouldn't think under that scenario that 3 minutes necessarily, without more, would constitute neglect.
Right, and I think that, the concern is that a lot of this is subjective and subject to interpretation, even though there are rules and laws that we're literally trying to put words to it and make it less subjective.
Right.
But I also, want to make sure that we've heard horror stories about vulnerable adults being abused and neglected, and I think we really do need to tighten it up, but we have to do it in a way that doesn't put our workforce in jeopardy.
Absolutely, and that's what we've been struggling with.
Yeah, so
You're struggling with it.
your options would keep the definition for neglect, but get rid of the definition for abuse. Is that what your
That is
options?
one of our options. We testified last week that the negligence standard be included for all the caregivers under neglect and for all individuals for purposes of abuse, with a carve out for licensed medical professionals.
Mhm.
After we proposed that, we heard there was still remaining concern from the unlicensed professionals who felt that there would be a continuing obligation to report and would be held to that standard and would have an impact on workforce. So that's why we propose these other options.
Okay, and the definition of neglect uses the term negligent in
Yeah,
the definition.
yeah,
That's,
they're different. They're different terms. They
They're
look very
different terms,
similar,
but
but
it does look very, compelling.
Yeah.
So we have heard this testimony
Yes.
previously, and we appreciate
I know, but
it.
we have like 75 bills that we're working on, and this is a subtle but important issue, and I want to make sure I understand it before I vote on it.
You're getting it. You got it. You got it. Any other questions? Do you have a final question, Senator Hardy?
No, I mean, I'm just, just trying to figure out if there's some kind of middle ground where everybody could feel more comfortable, well, we're protecting vulnerable adults.
Yeah.
I mean, it's like, that seems paramount, and I'm concerned that there's disagreement, but I also, just trying to figure out the
So
right
we
thing to
will
do.
get into discussion on this, but, thank you. We're gonna bring Katie up, but I see other people in the room are interested in commenting at this point. Since we've opened it up, I'm gonna allow for that to happen. I will say that there is subjectivity here. There's also trying to identify intent, which is extremely difficult. We know intent is one of those things that in the legal world presents problems. Then you can't come back 2 days later and say what someone's intent was. I don't know how you do that. I've never figured that one out. And we do have a reporting process, and we do have an inspection process. We have a licensure process. We have people who are concerned about their elders who are in these homes, family and friends who report all the time. And I can see an exacerbation of the problem that we currently have. So this is done, it goes on, but a lot of issues are being resolved in the bill itself, so just a comment. But I don't know, Jill, if you want to comment, or.
They're all nodding, yeah.
Yeah, I see Jill, and so do you each want to comment, or do you have?
I think why
know
don't I
that-
take point, and then I think others may fill in, is that all right, Madam Chair?
Yeah, let's do that.
Good morning, I'm Jill Olson. I'm the Executive Director of the VNAs of Vermont, representing home health and hospice agencies. So a couple of comments. So we are really concerned about keeping the definition of neglect, keeping the word negligence in the definition of neglect. So that I think the change to the definition of abuse would be an improvement, but it does not really solve the problem. Not following the plan of care essentially means that all of our workforce challenges become reportable. That's how we read this. And so I think the department is focusing a lot on substantiation and what they might or might not substantiate. But we're thinking about people having to report on each other, putting people on leave because they have been reported because a plan of care has not been followed. The term plan of care is that's a pretty high bar to me. It means everything goes exactly as it was laid out all the time. We were not comfortable with the idea of carving out just licensed professionals because home health agencies, designated agencies, nursing homes hire many, many caregivers who are not licensed. So any personal care attendant is not a licensed person. So we've already got a stressed workforce. We've already got people leaving the workforce for other industries that are much easier, where the work is much easier and the pay is often better. And we're going to add on to that this layer of potential punitive action. The substantiation is one thing. Being reported and investigated is a very uncomfortable process. It's uncomfortable to report on other people, and it's also uncomfortable to be the person on who was reported on. So the substantiation piece is really the end of a very long process. And so we're very concerned about the idea of roping in all of these other individuals into this process. I would also add that all of the licensed facilities, home health agencies, designated agencies, we're all highly regulated. There is a process, there is a complaint process in place. If a family member, a person who's being cared for, anyone thinks that there's something wrong with their care, there is a process and there is an investigation process. It's just not through APS. So it's through licensing and protection or through the Department of Mental Health. So there are many other layers of regulation where an organization is held to account if they're not able to take care of, to follow all the rules and regulations that they have in place. We have lots of rules under Choices for Care for training people, for how they do their work, for supervising them. But we also take on partial care for people rather than taking on no care, right? So it's really, really concerning that we're going to exacerbate our current really serious workforce challenge. I don't know if I missed anything. Devin Green, Vermont Association of Hospitals and Health Systems. I think we do understand the issue of wanting to inform the public of when these things have happened. And we would just say through all the processes that we have, those records are made public. And so if APS wanted to do something like put on their reporting registry, you should also go check these resources to employers or something like that, that could help inform the public without putting people under, getting reported, having to leave the organization while the reporting process and the substantiation process is being undertaken, and then, creating that problem with our workforce.
Okay.
There are ways to address the abuse registry issue that doesn't involve the reporting process.
Okay.
I would also just comment there, then some of these cases also can get reported to APS when the family complains. So there is already a process there too.
Right.
I'm not sure if this is a question for Jill. It might be a question for Katie, but these definitions and this process also apply, or do they also apply to the people who are cared for in community settings? Like, so the, vulnerable adults who are in the sort of home care setting. So,
I believe so.
yeah.
Yes.
And anyone who.
Yes. Yeah.
Yeah, so I mean, this is the thing, I'm worried about, and excuse this term, because I can't think of anything better, watering it down when we've heard horror stories about vulnerable adults and the way that they're have been treated in certain home care settings, the housing of adults with developmental disabilities and being like, closed in a room for a day while somebody and left alone. And that, I wouldn't want to water this down so those kinds of situations couldn't be taken care of, even though I hear you on the workforce issues and I hear you on the regulated facilities, but there's like a difference between a regulated facility and somebody's private home that's caring for a vulnerable adult. And that's another concern I have with taking out some of the language that would make it, maybe okay in a regulated facility, but not okay in other circumstances. So
I see that, right, go ahead, Julie.
I understand your concern.
And for the rest.
Julie Chester from Montfort Partners, and I understand your concern about the quality of care. People in the community living in shared living providers who are either individuals or families who bring someone into their home and they get paid a stipend on their contractors.
yeah,
Incidents like that, that's a critical incident that gets immediately reported to APS as soon as something like that is found. So there's nothing here that would prevent reporting incidents like that. But incidents like that really have more to do with the workforce, when we don't have workers to go out and do all those checks on a regular basis. And what this bill will do is reduce our workforce, because people feel at risk. Like, what if I forget a med? I'm going to be reported. This is not reliable income for me, because I can so easily be reported. I need to find other work that's more reliable, that I don't feel at risk. So we're worried it will impact our ability to recruit and retain shared living providers and the staff that go out and do the visits and make sure that people are getting the care they want. And the direct support professionals particularly, who have more limited training, and they're working under nurses like Jamie Brew, who was here last week, who takes a lot of responsibility to delegate her authority to provide medication to the staff. And we need adequate staff to do that. So we have vacancy rates. Last year, we had vacancy rates of 50%, and particularly some of the agencies, including that one where that person was found in the room. So the workforce for us is number one. The other thing that you did this year is put in new quality reviewers into the budget. So we'll have more quality review. So having quality reviewers doesn't solve the workforce problem. And Beth Seitler has always been saying, it's not gonna, in and of themselves, that's not gonna improve quality, but if there are quality concerns, we're more likely to see it sooner. But our number one thing is workforce, and we see this as detrimental to the workforce.
But to going back,
Recruitment and-
there is a way of reporting
We have critical
abuse within the
Yeah.
home environment.
With
Yes,
critical
I do
incident
know.
reporting, we see anything, we also do reports to Adult Protective Services. So
Right.
there's two different reporting mechanisms that are ongoing.
Yeah.
Plus, we have quality reviewers come in on a regular basis, I believe it's every 2 years, and then we have designation reviews. So there is a lot of oversight going on. The workforce issues did create some issues in the last couple of years that even with the oversight, we didn't get to it, but that's the bottom line issue is the workforce.
Stuart, you want to make?
Senator, thank you. And Dale is keenly aware and concerned with the workforce shortages and the implications of that. But to one point that Julie just made, so the designated agency can fire an employee. They can submit as required a critical incident report if negligence occurs as a result of some conduct by one of their employees. What that doesn't do, though, is it does not prevent that employee, after they're fired, from going to another agency and being hired. And there's no record of them having been substantiated for negligently, perhaps on multiple occasions, of abusing or neglecting a patient or a consumer. So that's the concern. There's no record. It can be handled internally, but no future employer would necessarily know that they were just let go by another agency because they repeatedly maybe neglected somebody or committed some form of negligence.
Okay, thank you.
We give you reference checks. Yeah, so I think that would come up in a reference check. And well, it's a very tight network, like we really do talk to each other. So nobody wants.
One agency to another, I understand, but not necessarily, they may not go to another agency. They may go somewhere else in the state and work.
We're actually having the exact same conversation down the hall when it comes to law enforcement and it's not always checked in a reference check unless somebody gives their permission to have their reference checked. Oftentimes, all you can say is, yes, that was worked here. And that's all you can say. You can't say why they were let go or if they were even let go. So I think that it's not necessarily as easy as you just described it. And yeah.
So I see 2 hands up, and I'm gonna continue this conversation. I think it's helpful, healthy and helpful. Go ahead, Jess.
Thank you, Jessica Barnard with the Vermont Medical Society. I just want to remind everyone that I don't think we're not advocating for an either or choice here. We're not saying get rid of the definitions of abuse and neglect that we have. So they include reckless and purposeful and knowing conduct. And I think honestly, what the dispute gets down to is what is the difference between negligent conduct and reckless conduct?
Yes.
Because we agree that if somebody is repeatedly ignoring, trainings, requirements, their duties, absolutely, we currently report that. We support keeping that in and reporting that. That it really comes down to what does negligence mean? And that is quite a low bar, especially maybe it's a little harder to substantiate it, but for what it requires to report, it is not performing your job in the way that somebody else in that same situation would have performed your job. Should somebody else have remembered a medication, remember to come check on that individual after 30 minutes? Probably so, but that can still be a mistake. That could not be, it doesn't mean it has to be intentional. It doesn't have to mean you intended any wrongdoing, you didn't intend harm, but somebody else might not have done it. So to us, it's really coming down to what is that mental state required when something goes wrong? And we think that's a very low bar that would require a lot of reporting of mistakes.
2 comments very briefly. Our neighboring state, New Hampshire and Massachusetts, they have no mens rea, strict liability. And so they do not consider the mental status of the individuals. I have that from personal conversations with the directors of both of those programs. The other thing that I would state is we are considering this about the substantiation and the burden that we have to prove when we substantiate. And we've had multiple cases overturned on appeal, specifically because we were told we did not show the individual acted recklessly, when in our mind, it was clear
that the individual neglected their duty, specifically on cases where they were tasked with supervision. Cases that I'm thinking about, multiple cases of individuals left in cars while the caregiver left to do their own business. And we were told in appeal that we did not show the person acted recklessly. And we feel that if you were tasked with somebody's safety, you should not be.
I guess, I know it's difficult for us to understand without understanding what the case was in that, but having the word recklessly in there, it sounds like you're utilizing that as a way of bringing concerns and rectifying problems, but the word negligence, I do hear and neglect is continue to use the word subjective, intuitive, whatever, and a much lower bar at a time when we're in a difficult situation overall, moving out of the pandemic and without workforce. So as you can hear me, I'm leaning in the direction of taking that language out, the neglect and the negligence out. And there's so much more in the bill that you're doing that is going to improve outcomes for our adults under protective services, that this will give us an opportunity to see how it all fits together. So we should probably move on from the discussion. I think we get the gist. We've gotten the gist previously, but I do want to bring Katie up to look at the bill with us a little bit. We still have some time, and I appreciate your being here. And the 3 minutes extended.
Yes, thank you. I used it.
Well, so, let's look at the context that we're talking about. We have the proposal amendment there that we had talked about in a previously. And let's look at the bill and the amendment together briefly. Can we do that?
Well, I can only pull up one document at a time.
Well, let's pick the bill up, and then if
Okay,
you
let me have
can
my
help us
folder.
know when, and if you can put it up on the screen, that'll help everyone. And then, as we're going through, we may be able to identify where the definitions are and what the amendment might do, and I'll put my amendment up, so.
Sure.
Because it's in section 1. It's really section 1 where we
Well,
have,
Section 1 is about
that's
50
our,
pages of the bill.
I know.
So section 1 is not very telling, but it's in
Short
the definition section.
Yeah.
So I should say Katie McLean, Office of Legislative Counsel. Good morning. You do have an amendment potentially for consideration. The first instance of amendment is to the definition of abuse. If you look at subdivision 1A, right now you have a list that abuse means any medical treatment that purposefully, knowingly, recklessly, or negligently places the life, health, or welfare of a vulnerable adult in jeopardy or is likely to result in impairment to the health of the vulnerable adult. And the proposal is to strike or negligently.
So we have purposefully, we have knowingly, and we have recklessly. It seems to me purposefully gets to the position of what one is intending. And recklessly, for me, covers, it's a big umbrella.
Okay. I'm gonna move ahead. So the next, I'm gonna move to vulnerable adult. I'm not looking at the amendment. I have the bill itself posted, the underlying bill. So the next, 21. So sorry, not the definition of vulnerable adult, neglect, subdivision 21. So in the underlying bill that came over from the House, neglect means purposeful, knowing, reckless, or negligent failure or omission by a caregiver that has resulted in or could be expected to result in physical or psychological harm, including a failure or omission to provide care or arrange for goods or services necessary to maintain the health or safety of a vulnerable adult, including food, clothing, medicine, shelter, supervision, and medical services unless the caregiver is acting pursuant to the wishes of the vulnerable adult, the vulnerable adult's representative, or an advance directive. Secondly, make reasonable effort in accordance with the authority granted the caregiver to protect a vulnerable adult from abuse, neglect, or exploitation by others. Third, carry out a plan of care for a vulnerable adult unless the caregiver is acting pursuant to the wishes of the vulnerable adult's representative, or an advance directive. Fourth, report significant changes to the health status of a vulnerable adult to a physician, nurse, or immediate supervisor when the caregiver is employed by an organization that offers, provides, or arranges for personal care. Neglect does not include self-neglect. So that is your definition of neglect. The amendment that you have on your website strikes or negligent.
And so the proposal of amendment would,
So it would just be purposeful, knowing, or reckless.
Madam Chair, can I ask a question?
sure,
So in the amendment, the first instance of amendment is strikes neglect or negligently from the abuse definition.
Yes.
The second strikes or negligent from the neglect
Yes.
definition. Okay. So I think that striking or negligent from the neglect definition makes sense because we're using the word to actually define itself, I think, or a different version of the word to define the root of the word. And that I learned in elementary school, you're not supposed to do when you define things. So I think that, but I think including keeping or negligently in the definition of abuse makes sense to me.
okay, so I'll have a difference of opinion there, I think, but that's okay. So, go ahead, Katie.
No.
Go ahead.
I was just gonna ask you how you want to proceed. Do you want to have a resolution on this neglect issue?
Let's,
Okay.
I'm not sure there's going to be a resolution. I think
Okay.
it's gonna have to be a straw poll, but I think the,
Okay.
or negligently for me, really propels the whole concept of subjectivity going throughout the definition. And it will cause significant issues in our adult protective services world.
Can we hear what the language will be without the or negligently, just so I can, is that possible?
Yep. So since I'm on neglect, I'll do that one first, since I'm already here.
Okay, on the bill itself.
Yep, so it would say neglect means purposeful, knowing, or reckless failure or omission by a caregiver that has resulted in or could be expected to result in physical or psychological harm, including a failure or omission too. And then that list that I just read.
Okay.
And then I'll go back to abuse. So that's the first definition. Abuse means any medical treatment that purposefully, knowingly, recklessly places the life, health, or welfare of a vulnerable adult in jeopardy. Let me do that one again. Any medical treatment that purposefully, knowingly, or recklessly places the life, health, or welfare of a vulnerable adult in jeopardy or is likely to result in impairment of health to the vulnerable adult. So, well, you continue to mull that one over. You have a third instance of amendment, and then there are two sort of outstanding issues that the committee, decision points that the committee needs to address. So the third instance of amendment, this was in 6911. Gonna make everybody following online seasick. Okay, so this has to do with records, what records the department can obtain in order to do an investigation or an assessment. So the language that the House landed on was this lead-in language in subdivision A1, subject to confidentiality or privilege protections. The department's APS shall have access to any records, documents, including client identifying information, financial records, and medical or psychological records necessary for the performance of the department's duties. After that passed, there was a conversation that by having this language subject to confidentiality or privilege protections, that potentially documents protected under HIPAA would not be accessible to Dale. So in order to allow Dale to have access to documents that would otherwise be protected by HIPAA, the proposal is to add in language. So I'll read what it would sound like altogether. Subject to confidentiality or privilege protections, except those provided by HIPAA, its corresponding regulations in 18 VSA 1881, which is the state codification of HIPAA. The department's APS shall have access to any records or documents. So it's creating language that specifies that HIPAA protected documents would be accessible for this purpose. And I think, although I will not speak for everybody in the room, that there's general agreement that that language is workable. The two. Okay, great.
It's great. Everyone is shaking their head. Yeah. So that, oh, thank you all. Like a dream.
So we have one instance of amendment.
Ooh, 1 for 3.
I know. And so, as I said before, there's sort of these two outstanding issues that the committee, is that okay if I talk
Yes,
about those?
please.
Okay,
Please do,
so we're moving back to the definition section. This is the definition of vulnerable adult. There's sort of two issues that the committee has heard testimony about and basically needs to make a policy decision one way or the other on. So going all the way back to the definition section, I think it's the last definition in the definition section.
What page?
I don't know yet. Let's see here, I'm close. Okay, the bottom of page 12 is where vulnerable adult starts. So one of the proposals, it relates to this subdivision C2. Yes. C2, the department is proposing on line 21 to add the word "the" before abuse, neglect, or exploitation. And the rationale behind their proposal to add the word "the" is the department would like to see a linkage between a person's vulnerability and the harm that they experienced, so as to be deemed a vulnerable adult under statute.
So it would link the disability with the
Yeah, it's creating a link to the harm, between the harm and the disability. Policy decision for the committee.
Yeah.
I would suggest if you do decide to have that linkage, that the word "the" is not sufficient to accomplish that goal, and you would want something that sort of spells out what your intent is.
So there may be cases where the individual's disability and the harm is not related. So if a person who is confined to a wheelchair but has all their intellectual faculties is convinced of a financial scheme or somehow taken advantage of financially, then that may not be linked with their disability. So I'm trying to sort out, if we put this in, what would that do to that situation?
Well, it would change whether or not the person is considered a vulnerable adult, and that is sort of the threshold question for whether there's an assessment or investigation. Is the person a vulnerable adult? So if you look at the language in this, beginning on line 19, it's looking at the individual's impairment as preventing them from protecting themselves. So do you want to impose a link between the individual's ability and their individual's potential vulnerability and their potential to protect themselves? Or for the purposes of defining them as a vulnerable adult, do you not want that linkage?
Yeah, I just find it really difficult. I understand that's important, but I also find it difficult to say that whenever you have take advantage of someone with a disability, it's linked directly to their disability. Help me out with it.
We were saying.
I mean,
I mean, think of examples where, oh, yeah, of course, they're being taken advantage of.
I mean, isn't somebody with a disability, when you think about protected classes, aren't people with disabilities part of a protected class, just sort of generally?
I think you're sort of asking, are there protections outside of this for person? I mean,
Yeah.
yes, everything that currently exists outside of APS would continue to exist and still exist. So yes, there are protected classes, and this, I mean, what I keep coming back to is what is the product of an APS investigation? In the end, it's having somebody either substantiated or not. And if somebody's substantiated, there's this list that employers would look at. So that is sort of the APS process. So the idea is, you know, is this an avenue that would also be an option for somebody who is considered a vulnerable adult? And then how are we defining a vulnerable adult?
But even if the ability to protect oneself from the abuse and neglect is not linked directly,
Mhm.
they're still in a category of people who have higher protections because of their status as a disabled adult.
But
vulnerable adult.
yes, and
Okay.
yes, and they wouldn't meet the definition of vulnerable adult under this chapter. So APS would not do a
I see.
investigation.
But they could go to the long-term care ombudsman.
There are other options,
or-
but what we're looking at in this definition is whether, I mean, that's the threshold question when a report comes to APS, is this person a vulnerable adult? And then the second question, is it abuse, neglect, and exploitation?
Mhm.
So if those criteria, they can't check the boxes on those, that sort of, you know,
Right.
carves those people out of being investigated through this process.
Right, so that we're just looking at this one,
Yeah.
like bubbled process, not the
Right.
broader
Yeah.
context of, okay, that's helpful,
Didn't
thanks,
we
Katie.
talk about this last week where there was
Yes,
a-
this is a deja vu
Yeah.
conversation.
Yeah, there was a young woman, a disabled woman who was sexually abused.
Right.
And they said that she didn't fall into this category because she could have protected herself or something like, do you remember that
Yes.
discussion?
This is the case, this is the case, yeah.
Yeah.
Yeah, so this is what I told Human Services upstairs about these cases. I've read through the cases. I'm, you know, I don't think the court necessarily is making a strong statement one way or the other, but it doesn't matter because you are the policymakers and you set the policy for the state of Vermont. Whatever you write, the court will interpret moving forward. So what do you want the policy to be
So
moving forward?
in the case of adult protective services, I'm looking at Stuart now, the linkage is important to have it between the impairment, the individual's impairment and the abuse.
Yes, because we're talking about placing someone on a registry for maltreatment of a vulnerable adult in a specific circumstance. And so if that person was able to protect themselves from the alleged maltreatment, should they be placed on the registry under those circumstances, or only for circumstances under which the person was not able to protect themselves? That's why.
Okay, so this seems like the word "the" might be helpful, or
So essentially you want the bar high.
similar phrase.
Higher than the.
We want there to be the connection because we think it's
Okay.
important for for the dignity of individuals who are deemed to be vulnerable. They're not vulnerable in every circumstance, number one. And number two, we have an individual who is facing placement on a registry as a result of misconduct. We want to make sure that they committed that misconduct against the person who was unable to protect themselves from that action.
And can you remind me, if somebody is placed on the registry, then that means they can't be employed in a field, in a job that would involve vulnerable adults.
While they are on the registry.
Yeah.
And is the word "the" strong enough to?
Katie is telling us, let's go back to Katie with that.
Okay.
Yeah, let's go back to Katie with that.
I don't think, I mean, I hear the argument of why they want to add the, but I don't think it is so obvious that that is what you're trying to do by adding the word the. I think if that is the policy decision of this committee, then maybe
What
let
would
me
it
work
look
with.
like? Can we see what it would look like so
Stewart
that we
outlining.
understand
Yeah,
the implications?
yeah.
That would be
I think we
helpful.
just sort of need a statement that specifies what your intent is.
Let's add that into the proposal.
Okay.
Yes, sir. For the record.
Thank you. I'm Michael Benvenuto from Vermont Legal Aid. I testified last week. And just to be clear, that advocates for vulnerable adults are strongly opposed to creating that linkage. We think it's really bad social policy. So it is really restricting the definition of who would fall as a vulnerable adult. Somebody in a wheelchair who's financially exploited by their caregiver is financially exploited by their caregiver. They are a vulnerable adult, even if their disability is physical. So we're strongly opposed to adding that concept of a linkage. It's changing Vermont law and changing public policy in Vermont.
But wouldn't that person be, if I may,
Go ahead.
your example, somebody who is not considered a vulnerable adult, who is subject to financial exploitation by somebody else. There are still laws that are govern financial exploitation of anybody. How is that different? Or I'm just trying to wrap my head around why is, in your example, why it makes a difference.
Well, part of it, I mean, this is for vulnerable adults are a special class of people. This law is intended to provide additional protection for them. And so adding this just makes the determination of who is a vulnerable adult and not vastly more complicated and confusing and difficult. Where instead you look at the person, you're evaluating, do they fall into that class of individuals, regardless of whatever is alleged to have occurred to them at that given time, that week or that month? Are they vulnerable because of their impaired ability to protect themselves? That's how other states treat this, as far as we can tell. That's how Vermont, that's what the current Vermont law is. So that person in the wheelchair with physical disabilities is dependent on their caregiver, and that dependency creates vulnerability, even if it doesn't relate to their ability to financially protect themselves. They're vulnerable because of their dependency.
Thank you.
John Gordon, just a brief comment. The addition of the word and the linkage between the vulnerability and the condition or disability would only apply to that one specific portion of the definition. If the individual had a caregiver, that means if the individual is not able to provide for their own care, they would be considered vulnerable under a previous portion of that definition. So only if they would not be considered vulnerable under the 4 or 5 previous sections of that definition, they did not qualify for any of those other definitions of vulnerable adult, would you be looking at that last section, which is regardless of everything above, they had an impaired ability to protect themselves. And to speak to other states, no other states that I'm aware of go as far as Vermont does, and including that last portion definition that really opens the door, so to speak, for anyone to consider vulnerable.
Okay.
Right, there are ors in there.
Right.
So
They're
yes,
all
like, and as you were speaking, I was like, does it say vulnerable? Does it say vulnerable?
Senator Gulick.
I'm trying to go back in time again to a previous conversation. Was this related to the conversation we had about if someone is wearing glasses, for example, they're vulnerable? Okay. Thank you. Just making connections. That's helpful.
I don't remember that.
Okay, well, let's look at what the implications are. I mean, there's a difference of opinion here that we're gonna have to adhere to what is before us as it came from the House or not. That's really where we are. And what's the last decision point? Thank you for bringing all this up.
Yeah.
We
So the last piece is this language right here on lines 11 and 12 about clinical eligibility to receive long-term care. The proposal from Vermont Legal Aid and
Yes.
Code is to move that language into subdivision B, thereby a person's clinical eligibility for long-term care Medicaid waiver services alone would make them a vulnerable adult. So does their clinical eligibility alone qualify them as a clinical adult? Or as in C, it talks about regardless of residence or whether any type of service is received, has physical, mental, or developmental disability, infirmities as a result of brain damage or mental condition, infirmities of aging, or is determined to be clinically eligible to receive long-term Medicaid.
Well, there's an or there, so I'm not understanding why.
Yeah, I'm not understanding.
Why would you do that if you have the or? Help me.
I don't know that I can. Hold on, I'm
Okay,
reading.
Michael, you're
Subdivision
here.
B, yeah.
You brought it to us.
So yes, Michael Benedict from Mountain Way. The reason you would move it, there are ors for all these sections, they are independent, which is be there if somebody's receiving personal care, often from a home health agency or other service. And then by moving the choices for care, long-term care, Medicaid, clinical eligibility in there, that person has been determined by Dale to require personal care. So and that then becomes independent of D, which is what we call the functional test, which then they might need care and or they have an impaired ability to protect themselves. So it's really, if somebody's been found eligible to need personal care by Dale already, they should be treated as a vulnerable adult without further inquiry. So that's the reason, just for, it's sort of like, it is a bit of a clerical change, but it's making it clear that if they've been found eligible by Dale to need personal care, then they should be treated as a vulnerable adult because they already meet the standard under the statute.
Okay, we're gonna have a comment. We've got a comment from over here.
Jessica Barnard, Vermont Medical Society. This came up in that house, and I just want to share the perspective of the mandated reporters.
Yeah.
And the reason they didn't move it up in the house was that there is no way, or very little way, that a outside mandated reporter would know that somebody has been determined clinically eligible if they're not actually receiving the services, or it's not linked. You'll see, because it has to result in some impairment of their ability to independently engage in activities of daily living. So right now it says you have to be determined eligible plus have that results in your inability to engage in activities of daily living, which that's something objectively that an outside physician or caregiver could say, oh, this person needs assistance. But just reminding everybody that this is not just how issues are substantiated, but when you have to make a mandated report to determine if somebody's a vulnerable adult, there wouldn't be a way to know that.
Got it. Okay. That's helpful. All right. All right. Okay. Is there anything else in here that we have?
Oh, so at this point, it sounds like you have 4 outstanding issues. You have the negligently and the definition of abuse and the definition of neglect. You have whether or not to have that linkage and whether or not to move clinical eligibility.
Okay. So what I'm going to suggest is this, we've got 20 minutes, this is good. Let's go through each one yet once more, so the committee has some clarity about what our decision points are, and open up for discussion. We'll try and spend about 5 minutes on each one and then take a little break.
Okay. So I'll bring this back to the beginning,
Please.
which was the definition of abuse.
And I will say that I have had conversations with the agency on this, so we'll see where we are with that.
Okay, so right now, the version that came from the House, abuse means any medical treatment that purposely, knowingly, recklessly, or negligently places the life, health, or welfare of a vulnerable adult in jeopardy, or is likely to result in impairment of health to the vulnerable adult.
And the question here is, the word negligently.
You'd be striking the phrase or negligently, putting an or before recklessly.
And so let's take some time to ponder on that. I'm gonna just suggest that you do that, and then I know there will be conversations outside of the room, and that's, I think, is important to our understanding. Okay. Any questions of Katie? Okay.
So next we have our definition of neglect in subdivision 21. Okay, so we have neglect means purposeful, knowing, reckless, or negligent failure or omission by a caregiver that has resulted in or could be expected to result in physical or psychological harm, including failure or omission too. We have the list. We go through it again. The proposal is the same as above, to strike or negligent and have or before reckless.
So it would be knowing or reckless failure.
Purposeful, knowing, or reckless. Yep.
And so take negligent there, but it is neglect.
And
Okay.
then,
Any questions of
sorry.
Katie on that one? Okay,
And then our definition of vulnerable adult, we have two issues to tackle here. There it is. Okay, so the first issue is moving clinical eligibility from subdivision C to subdivision B.
and this is in the context of what first? The context of reporting?
So this is the definition of vulnerable adult. Who is a vulnerable adult? So that will be sort of the threshold question that's asked. And so now I understand that by moving it to B, receipt of personal care services alone would qualify somebody without having any other assessment or determination done pursuant to C. So that's one issue. The second issue is in subdivision, I think C2, C2. And this is the language around having a linkage. Is there a link between the person's vulnerability and their ability to protect themselves from a harm?
So if the linkage is in there, it really, it narrows the world of adult protective services in some ways. Who is covered? I understand.
Yes.
Yeah.
Well, not necessarily, because there are lots of ors in here. There are a
Oh,
whole
yeah.
bunch of things that they could do this or this or this or this. And
And
so
then
I'm
and.
not sure that. it
So,
does
yeah, do
narrow
take
it.
some time, look at that. So this is the fourth one, quick, so go ahead, Senator Hardy, you're asking a question about the ors that are in there, and will it narrow or will it not?
Yeah, I mean, it doesn't seem like it would, because there are a whole bunch of different things that it could be. They would be a vulnerable adult who is or this, or this, or this, or this. And then the last one creates a linkage. And if none of the other ones apply, then this one could apply. They could be a vulnerable adult in this case. So I don't, it seems like there are a lot of means to get to the definition of a vulnerable adult. So I mean, I agree with Katie that just in putting the word "the" in there is not sufficient, that there needs to be something else that sort of spells out the intent. And I'm wondering if Katie could
We asked
work
her
with
do that.
people
She's got
to get some language that makes sense.
It could be something like the ability to protect the adult from the specific abuse, neglect, or exploitation that the adult experienced, or
Yeah.
something like that.
Okay, so yeah, those are the four places where we are. My suggestion is to please go through the entire bill. There's a huge amount of work in the bill. There are a lot of changes in the bill and improvements to APS in the bill. And what we're looking at are kind of the last bits, but I will say that I still lean toward the removal of neglect and the negligent piece. And that we will see the results of the rest of the bill going forward. And then we'll pick up the other pieces as we go forward. We'll have that discussion tomorrow. We have it on the agenda for tomorrow.
Sorry for the repetition, but could you please go over number one more time for me?
Yes.
Thank you.
So that's the definition of abuse. And as passed by the House, we have abuse means any medical treatment that purposely, knowingly, recklessly, or negligently places the life, health, or welfare of a vulnerable adult in jeopardy or is likely to result in impairment of health to the vulnerable adult. And the proposal is to strike or negligently.
Gotcha. Thank you. Okay.
Okay, you're good.
Yes.
I'm glad you're good now.
One of us.
All right. Any other questions or comments at this point? So yes, please do look at the bill and consider those 4 points as you're going through. And then I know that you're going to be talking with folks outside the room, and I think that is important. And if there are examples that people can bring to us that are helpful, that's fine. But examples are frequently outliers rather than what happens consistently and what work does go on in some of our either homes or facilities. And just consider all of the above. All right, so we're gonna go offline, Alex, and we'll take a little break.